Good morning, everyone. I am Kamala Rampersad de Silva, Chief Executive Officer of the Caribbean Corporate Governance Institute, and I would like to thank you for joining us for this important discussion on compliance with the Nonprofit Organizations Act of 2019. Across the Caribbean, nonprofit organizations play an indispensable role in strengthening our communities, supporting vulnerable groups, advancing education, culture, health, and the environment, and contributing generally to national development. To continue fulfilling these missions, organizations must also demonstrate that they are well governed, transparent, and accountable. Compliance is therefore not merely about meeting legal obligations. It is about building public confidence, protecting the organization's reputation, assuring donors, beneficiaries, regulators, and the wider community in general that the organization is worthy of their trust. We too are a nonprofit organization. Established in 2012, we are a nonprofit membership organization. And we currently have about 350 members from a range of private and public sector organizations across the Caribbean region. Trust, therefore, is a key element to maintaining our reputation. Our members come from over 10 Caribbean countries. We welcomed our first member from Antigua and Barbuda a few weeks ago, and the Cayman Islands earlier this year. Other members are from here in Trinidad and Tobago, from Jamaica, Barbados, Belize, St. Lucia, Guyana, Grenada, the British Virgin Islands, St. Martin, and Suriname. And through our bundle membership with JMMB Bank, we also have members from the Dominican Republic and Colombia. Our mission is to help improve corporate governance practices. And to do so, we run a series of panel discussions, workshops, and conferences throughout the year. We have a very important policy development series, which is facilitated by Claire Gomez Miller. This workshop will be on August 24th and 25th again this year. Having the right policies is crucial to the governance of your organization. We also run our training modules in corporate governance, which will be held during the month of October. We also have a 2-day workshop on AI deployment readiness for organizations with Ian John, the CEO of CyberEye. We also have our 7th annual global conference at the start of November and our end of year networking event later that month. So I invite you to visit our website for details on these and other events, which we have already opened for registration. And if you are not yet a member, do consider joining us and actively contribute to the conversation on how we can improve leadership and governance to achieve sustainable outcomes. Persons may join us as individual members, or your companies may choose to pay for bundle membership, which can cover 6 to 12 members. We do have many persons who are joining a CCGI session for the very first time, and so you will not be as familiar with our housekeeping rules. But I want to share that we wish for you to have your full names on your devices because we are not in a webinar. This is a virtual meeting room which allows you to put messages in the chat, which can connect with anyone else in the room. And therefore, we also need to ensure that every person is identifiable. Also, because we do provide certificates of participation at the end of the session, we need to know who is present with us. We ask that during the presentation with Sonji, you keep your microphones on mute. You can always place comments in the chat feature during the session. If you do have an urgent question, do raise your hand using the virtual icon. Your virtual hand, that is, using the icon at the bottom of your screen. But we will engage in a question and answer segment at the end of Sonji's presentation to be able to treat with your concern. We will be putting a survey link at the end of today's session, and we ask that you take 2 minutes and give us your feedback, please, because we like to ensure that we are meeting your expectations. At this point, I'd like to recognize the CCGI team, acknowledge and thank Laura Sinanan and Quentrell De Silva for their hard work. They are part of a new initiative of business operations and governance assistants who are being trained to eventually support organizations with things such as development of board charters, policies, or even serve as recording secretaries when there is a need. And that is because there's this new career developing for governance officers. And therefore, we also will be starting a series of courses entitled CCGI's Governance Essentials, which will take you through the foundation of what it means to be a governance officer, providing support for an organization. We are currently in discussions with CTS College to begin offering those courses from September. So you could look out for more details on that in the coming weeks. So as we move to today's workshop, recent developments have reminded us that compliance cannot be taken for granted. It requires informed boards, diligent officers, and sound governance systems, as well as a commitment to keeping policies, records, and statutory filings up to date. Today's session is an important opportunity not only to understand what the law requires, but also to strengthen the governance practices that enable organizations to operate effectively and sustainably. We are especially pleased to have with us Sonji Pierre, whose knowledge and practical experience in this area will help us better understand our responsibilities and equip us with the confidence to ensure our organizations remain compliant, resilient, and focused while delivering lasting impact. Sonji, I'm proud to say, is a member of CCGI, being a past president of the Trinidad and Tobago Chamber of Industry and Commerce. She was reminding me earlier today, we invited Sonji to do a presentation on this nonprofit act almost as soon as it was proclaimed during the height of the pandemic. And so this is actually the third time she's doing a presentation for us. So I'm about to introduce Sonji now, and you will see from her background that she is really more than equipped to providing this guidance for us. Sonji has over 26 years of experience in property law, conveyancing, and commercial transactions. She has advised major financial institutions on security documentation, commercial leases, and landlord-tenant matters. She also has extensive experience in mineral title analysis and oil mining leases. Her experience includes international trade law and antitrust law, specifically fair trading and competition law, having worked as a legal trade specialist at the Ministry of Trade and Industry. Her current legal practice includes intellectual property, probate, and estate planning. Previously, she served as legal officer at the Petroleum Company of Trinidad and Tobago and at the Trinidad and Tobago Chamber of Industry and Commerce. Sonji is also an associate tutor at Heward Law School and has contributed to intellectual property law reform in Trinidad and Tobago as a member of the ministerial appointed committee. She's the holder of a Bachelor of Law degree from the University of London and a legal education certificate from Heward Law School. Additionally, she's the holder of a Master of Laws degree, majoring in conveyancing and contracts and international trade law, and a postgraduate diploma in international relations with the University of the West Indies and antitrust law from the College of Law in England. She's the team lead and head of conveyancing and property department of the law firm JCS Caribbean Law. She has served as president of the Trinidad and Tobago Chamber of Industry and Commerce during 2025 and 2026 and is now the immediate past president. So as I shared earlier, this is the third occasion that Sonji is presenting for us at CCGI on this legislation. the Nonprofit Act, which was passed in 2019. Sonji, we are so proud to have you, and I happily hand over the podium to you now.
Thank you so much, Kamala, and thank you for that very warm welcome, quite detailed. And you're right, this is the third intervention of my presentation on the Act. As I was reminding you earlier, you were one of the first persons that had reached out to me to do a presentation to your members when the Act was passed in 2019, and we did a session in 2020 and in 2023. So again, good morning, ladies and gentlemen. I must say a special thanks to Kamala and the team at CCGI for having me here today. It certainly is a pleasure to be with you today to discuss the Nonprofit Act, which is a piece of legislation that has become increasingly important, as Kamala correctly said, not just for boards and directors, but for trustees, executives, and anybody involved in governance and the management of nonprofit organization. The act was enacted in 2019, as we said. It was proclaimed in June of 2019, but this is important. It was amended 3 times in 2020, 2023, and just recently in 2026, as you would have seen reported in the dailies yesterday. And these amendments were structured to bring the act in compliance with our FATF obligation, FATF standing for Financial Action Task Force, right? So nonprofit organizations play a very vital role to our society. They provide critical services, support for vulnerable communities, they advance education, they involve in culture, religion, sports, and countless other causes that contribute to national development. Because these organizations operate in the public interest and they often depend on the trust of donors, members, and beneficiaries and the wider community, they are held to a high standard of accountability and transparency. The Act, therefore, was introduced to strengthen that accountability. The Act seeks to ensure that nonprofit organizations are properly governed, they maintain adequate records, they comply with reporting obligations, and most importantly, they are not vulnerable to misuse for unlawful activities such as money laundering and terrorist financing. And while these objectives are important, the reality is that many organizations, many nonprofit organizations, struggle with compliance, not because of deliberate wrongdoing, but just because they are unaware of what their obligations are, or they lack the systems and the resources necessary to meet these obligations. And that is what this session is all about, to bring this awareness to members of the wider community. So today's session is intended to be more practical than legal. I hope I could achieve that. We will examine the key requirements of the Act. We will identify some of the most common compliance pitfalls, and we will discuss governance practices that can help NPOs become compliant, remain compliant while fulfilling their missions or their objectives effectively, right? So what I encourage you to do is to think about your own organizations, those organizations that you are involved with, how you wish to proceed. Ask yourself these questions. Are our records up to date? Are we reporting our reporting obligations to the regulator being met? Do we have appropriate governance and financial controls in place? And if a regulator were to come to you tomorrow and ask you to produce information, can you confidently demonstrate that you are compliant? Ultimately, compliance is not simply about avoiding penalties, and we will look at some of these penalties shortly, or satisfying regulatory requirements. It is about protecting the integrity of the organization. It is about preserving public trust in your organization. It is about safeguarding funding opportunities. All NPOs, all clubs are looking for funding opportunities, which we are aware of, right? And it is about ensuring that your organization can continue to deliver on its purpose for years to come. So what I hope at the end of the session is that you will have a clearer understanding of what your obligations are under the Act, and more importantly, that I would leave with you some practical steps that you can strengthen compliance and governance in your own organization. So I had a presentation that I had did for CCGI in 2020 and again in 2023, but I updated that presentation at the encouragement of Kamala, which is what I am going to share with you today and take you through my presentation. So let's make sure this works again. We did a test run. Here we go. Right. And then Kamala said, look for the champagne cup.
Yes.
That's the champagne cup
There we
there.
go.
Yes, champagne cup. Right.
There we go.
There
Nice.
we go. So in my opening remarks, this is what I said that I'm going to go through with you today. We're going to look at why the act is important. What are our registration obligations? And Madam CEO did alert me to your registration, and I understand that the majority of you are representing sporting clubs or clubs that are associated with some form of objective as opposed to other types of NGOs. So what are the registration obligations? I'm going to walk you through that, how you are to register, and what information you need to have at hand to register. I'm going to look at your reporting requirements, your governance, CML and AML and CFT requirements, and then we're going to look at some compliance roadmaps. And most importantly, throughout my session, I hope to identify for you some of the common pitfalls with compliance. So why is the act important? The Act seeks to provide registration and regulation and supervision for all nonprofit organizations in Trinidad and Tobago. What nonprofit organizations are captured, I will discuss with you shortly. But there are three critical reasons why the Act is important. The Act is intended to increase transparency and accountability in the NPO sector. Why? Because that sector was identified as a very vulnerable sector. For those of you who are in AML CFT and familiar with FACTOR, you would know about recommendation 8, FATF recommendation H, which specifically speaks to the nonprofit sectors. And what they had identified is that this sector has the vulnerability of being abused by people who had ill intent. Terrorists, people who were trafficking drugs, people who were money laundering, or people who were involved in counterterrorism activities. So they were filtering funds through these NGOs to put towards a greater purpose that was not proper or legal. And because of this, the FACTOR task force mandated all countries to introduce legislation to ensure that the NPO sector is protected. That's what it is about at the end of the day. Make sure that the protection is there because of its vulnerability, that it will not be subject to abuse. So you have the transparency, then you have the compliance to make sure that you are not subjected to counter money laundering objectives. You are not involved in counter financing terrorism, or you are not involved in the proliferation of weapons of mass destruction. And you may not be directly involved, but you may be indirectly involved by the receipt of donor funds. So to prevent the misuse of NPOs for unlawful purposes, including, as I said, money laundering and terrorist finances, was one of the other reasons the act was passed. And then thirdly, and quite importantly too, and Kamala said it, and I think Kevin also mentioned it, it is just to put a proper structure in place, regulations in place for NPOs. All of us on this platform are in some way involved in the NPO sector, or may have been involved in the NPO sector. But importantly, all of us at some point in time would have been approached by some body, not individual body, meaning a group of persons, for assistance involved in the NPO sector. If it's a swimming club, a sporting club, a dance club, a cultural club, a religious organization, we would have been approached for assistance, and I mean financial assistance. What we did not know or are not aware of or took cognizance of is what our money was being applied towards, what purposes were being used for the fulfillment of that financing. We would knowingly give it because we say, oh, it's a nice village club. It is somebody involved in doing good for the community. And we believe them and we hand over our money, no questions asked. But before this act, there was no regulations. So people just did what they want. And I don't want to believe that people are still doing what they want. I hope not. But the act was intended to prevent that misuse of public trust, that you come to the public for donor financing. Even if it's $5, it could be $5, $5,000 or $500. It don't matter. It is your money going towards a cause. You have the trust and confidence that that funds that you're putting towards this enterprise is going towards the fulfillment of the objectives stated by the enterprise. So that's where the regulatory part of it comes in. So let's look at some key provisions of the act. Who is captured? Everybody. And I'll break that down for you a little bit. Anybody or group of, when I say body, I mean in group, right? Any group of persons, incorporated or unincorporated, who come together for a purpose captured by the act. And I'll give the specifics just now. What is required is that all those groups, clubs, sporting, dancing, education, whatever, they are compulsory required to be registered. So registration is required for all NPOs, safe-friendly societies, at the passage of the act. The act did give a grace period for registration, which has since expired because that grace period was extended. It was 18 months from the day that the act was proclaimed, which was June 2019, as I mentioned. That 18 months was extended twice. So that extension has gone through. So the compulsory registration now is mandatory. You must register with the act. That's what the section 5.1 of the act says. If you don't register with the act and you continue in your wanton missions without being registered, you are guilty of an offense. That's what section 5.2 says. Anybody contravening section 5.1, and what is section 5.1? You must register. So once you don't register, you would be on conviction and indictment, liable to a fine of $50,000 and, it's not all, and imprisonment for 7 years. So it's not a risk you want to take for the club that you're running, that you put in your heart and soul and knowing that you are doing a good deed, but that good deed is just part of the regulatory environment now. That purpose, that objective is just part of it. The key part is that the act requires mandatory registration. That's what section 5.1 says. As Kamala said, her entity, which is Caribbean Corporate Governance Institute, is registered. It is registered because it is a non-profit company. So the act caters for, this is the NPO Act, right? The act caters for companies that are registered as non-profit companies. So you could actually register a company under the Companies Act, whether it's a limited liability company or a non-profit company. So that still remains. You could register your non-profit company as a company under the Companies Act. But when you do so, you must then also register as a non-profit organization. So it's 2 tiers to your responsibility. Yeah. Those non-profit companies that were registered prior to the enactment of the act automatically would transition to an NPO register that the Registrar General Office created. So the Registrar General Office created a non-profit register of all non-profit organizations, and all companies that were registered as non-profit companies were listed under that NPO register. So that's what section 8 says. So you don't need to re-register, so to speak, as an NPO if you were registered before the act. What you were required to do is that you must complete the risk assessment questionnaire. So you must complete that risk assessment questionnaire, submit it to the Registrar General, and you will get a certificate endorsing your registration. So really and truly what you will now have as a non-profit company would be your certificate of incorporation under the Companies Act, and then your certificate of registration as a non-profit organization under the Non-Profit Organizations Act. Very importantly, who is a controller? You will hear this word quite a bit throughout our conversation this morning. A controller is a person who has control or management of the NPO. And identification of this person or these persons critical because the obligations, the reported obligations really fall on those persons who are identified as the controller. So any person who has management or control of the NPO will be considered the controller. So if it is like CCGI, that is a non-profit company, you will have a board and you will have a board of directors. So your board of directors and your chairman, all controllers. And when we come to the fines, you would see how all of them could be liable if there's any wrongdoing. Your CEO has management control, a controller. But we have NPOs that are not incorporated. We have NPOs that are unincorporated associations. People just come together. How do we identify who the controller is? It is the person who exercises control, administration over that club. That is the controller. So you may have one or two or three of those. Somebody earlier, when we were doing the introduction, said that they are the treasurer of a particular club, a sporting club, controller. You're controlling the finances, so you're the controller. You would see how onerous your obligations are under the Act once you have identified those persons who are the controller. So that's Section 3.1 of the Act. So let me break down for you exactly who the Act covers so we can have a clearer picture. As I said in my earlier slide, an NPO can be incorporated or unincorporated. The incorporated is easy. That's like CCGI. That's like the Chamber of Commerce, of which I am a director. Our entities are incorporated under the Companies Act as a non-profit company. So we automatically are classified as an NPO, right? So those are the easy ones. You have many, more than 90%, I would say, of persons involved in charitable works are not incorporated as companies. They just come together for a purpose. And we will look at some of the purposes. Those unincorporated groups or associations of persons who come together to advance a particular purpose, you're an NPO. Once you come together to advance a particular purpose, you are classified as an NPO and you are subjected to the provisions of this Act. What are those purposes? Promotion of patriotic or religious, philanthropic objectives, charitable purposes, educational purposes. Many schools don't even realize that they're supposed to register. Many schools. Churches don't even realize that they're supposed to register. Cultural, scientific, literary, historical, aesthetic, social, professional, fraternal, sporting, athletic, or any other useful purpose that brings people together and raises funds to advance those purposes or objectives. You come together for a purpose. So I think somebody was in a cycling club. You come together. You raise funds for the advancement of your young cyclists, either to train them, to get them to compete in overseas competition, to fund their overseas mission. You are an NPO, and you are subjected to the provisions of the NPO Act. So I hope I made that abundantly clear, because that is where the misunderstanding starts, whether or not what I do is classified under the provisions of the Act. So you might say, okay, I'm just involved in a little village cultural, you know what you call the community events that you have, the best village stuff. It's just a small group of us. It's just 5 of us, 4 of us. It don't matter. It's a group. A group is 2 plus. That's group, right? You come in together, you meeting, and you discussing how you're going to advance the objectives of your club, of your association. You are considered an NPO. I'll just put one caveat there. The Act does, in fact, have a little exception. Uno. I've been asked this question over and over. If one is one. One is one. One can be one every year. So you can't say you come together this year to raise funds for a purpose, then you come together again next year and the year after that. That is not one. one time, a one-off. So you have some situation in your community and you're trying to raise funds to help somebody that in whatever situation, whether it is educational, sport, and whatever it is, and you come together, you raise funds for that purpose, which really is supposed to be classified as an NPO. The Act creates an exception if it is one-off. One is one, not one every year, right? So we understand, or we are very clear, all of us, basically, once we are involved in these kind of philanthropic, charitable activities and purposes, educational and sporting purposes, will be classified under the provisions of the Act and are required to be compliant. So let's move on. Your registration obligations, as I said, mandatory. The grace period passed, long time. So if you haven't registered, get cracking on it, because I will expose some of the fines. Well, I did already, $50,000 plus 7 years in jail. So I'll just remind you, $50,000 plus 7 years in jail. Get yourselves registered. You get registered, you get your registration certificate, and you have a registration number, but your obligations don't end there. It's not simply about registering and then putting up on a fancy wall, embalming it, your registration certificate. You have to maintain your registration. And what does that mean? You have to ensure that your proper recording of all information pertaining to your organization, your club, your associations are kept up to date and furnished to the Registrar General. So here what? You have a club today, the neighbors come together, the people in the community come together for this particular club. You have, the main persons who are involved, and then it change. Members change, controllers change. That is not something to take lightly. You have to have that information documented, and you have to furnish the Registrar General with that information. You have to update the Registrar General's department every time you have a change in controller. Every time you have changes in your membership, that information must be available to the Registrar General. And the amendments that I spoke to earlier, remember I said the Act was amended 3 times, the last one being what was proclaimed on the 31st of July by our president. What it did, those amendments, basically, what it is just strengthen the penalties and fines that are paid for non-compliance. That's all. The requirements remain the same. What it did is just increase the penalties and fine when you don't comply with the provisions of the Act. So this is, I've identified, I try to in most of my slides identify what I deem to be the common pitfalls, right? So common compliance pitfall will be your failure to update the Registrar General with changes. You think you're registered, you have your certificate of registration, you're good to go, you put it up on your wall, you put it in your safe. That is not the end of it. Your registration obligations extend to keeping those records and updating the Registrar General of those records anytime you have changes in controllers and in your membership or your office moves. You have to tell the Registrar General as well, right? Your annual reporting requirements. So like CCGI and the Chamber of Commerce, of which I am attached, because we are non-profit companies, we are required to file annual returns every year. It's specific. There's a timeline involved in that. You have to ensure that you adhere to those statutory deadlines. So once the Act identify a date by which documents are to be filed, you must file those documents by those dates. If you don't file it by those dates, not only would you be exposed to an administrative fine, you may be subject to additional fines based on the fact that it becomes an offense. So what you need to do for your annual reporting, just to reiterate, maintain records of all of your supporting documents. What you should do is establish an annual compliance system where you can verify that the information in your records are the information before the Registrar General's department. So what I've stated there as a best practice is that NPOs should have a calendar with all their statutory filing dates and requirement dates, electronically, however you want to maintain it, which will give you the little reminder triggers when you need to do what by what date, just to avoid any exposure to a penalty or a fine. Yes? And later on, when I speak about some of the offenses, you would see how serious, this non-compliance issue with recording really is. Yeah. So you must also have a record. Your record keeping obligations are critically important. Your record will not just be a record of who your controllers are, who your members are, but your financial records, your bank statements, board meetings. I use board there, but when I say board, I also mean the group of persons who have the responsibility for the management and control of the NPO, because it may not be a company, it may just be a club or an association, right? Donation records, any grant funding you've received, any funding agreements, your asset register. Those are critical documents that you must have in place, and you must keep them for a minimum period of 6 years. I want to go to the financial records point a little deeper, just to tell you, because I deleted this slide from an earlier presentation I have, what comprises the income of an NPO. When the Act speaks about the income of an NPO, what they're referring to. So the income of an NPO includes income that you get from the provisions of goods and services. So you set up your little bake sale or whatever to raise funds. The income you generate from that, that's your income. If you have property and you rent the property, that's your income. If you receive interest on any investment instruments that you have, that's your income. Donations, grants, and subventions. So if you get subventions from the states, if you get subvention from international or regional organizations, those are classified as your income, and a proper record of it must be kept. Any loans that you take and any other income of monetary value or worth, it is considered your income. So if you get services in kind from a donor, so a donor says to you, say, somebody, I'm going to call a name, but let's say somebody in the telecommunication sector says to you, okay, I could give you a sponsorship of 50% in cash and 50% in kind, which would probably be mobile services, internet services. That is your income. That translates to a financial contribution that you receive from this donor. That donor in the telecommunication sector might be a legitimate source. But what about if it is not a legitimate source? If it's somebody from overseas that you think, oh, I land on this golden egg here. This person giving me, cash plus kind out of the goodness of their heart. And you don't know that they are already trying to launder money or pass funds through you for illicit purposes. You have to keep a record of all income that comes into the organization, right? Coming back to the NPO. Remember I said those are with the responsibility, right? So a controller of an NPO who fails to ensure that the records of the purposes and activities of the NPO are kept. Once you fail to do that, and they can prove it, you commit an offense and you are liable on conviction to a fine of $50,000. And they like to use the imprisonment. They ain't giving you either or. A fine of $50,000 and imprisonment for 7 years. So just keep your records. As I said, a common pitfall will be poor record keeping, missing information. You are being audited by the Financial Intelligence Unit, and the Financial Intelligence Unit says, well, where you get this money to build this building? Where you get this money to renovate this building? Where you get this money to buy this building? Buy this computer? It may not be a big red building, but it might be a small little building or a computer or a desk. But you bought it. Where did you get the money to purchase this item? And you cannot account for it. So your failure to keep your records, missing a record, if it is not documented, it is difficult to prove, because then you're going into hearsay, and no court of law will accept that as proper evidence. You will find yourself in problems, right? Financial management accountability. Just tie back into the conversation I had with you about what is your income. Now that you understand what your income comprises, it is not just money that you earn and raise. You see, it's a whole plethora of resources that the Act has classified as the income of the NPO. So you have to ensure proper stewardship of that income. Appropriate controls are implemented to account for the income, and that you have, as an MPO, written and transparent financial policies and practices. Any cash handling without controls, or where you have no segregation of duties. So you have your treasurer, who's your secretary, who's your president, who's your chairman, who's your everything. Your one-stop shop kind of thing. No. The NPO access, no. Yes, you might be Barbie and have plenty of occupations, but you cannot do it all. You have to have segregations of duties. You cannot commingle funds to say, okay, yes, we are raising funds for this purpose. We don't have a bank account yet, but no problem. I will just put the funds into my account for the time being. No, no, and no. You cannot commingle funds. You cannot have unauthorized expenditure. Say, okay, no problem, just go down the road and buy this barbecue pit because we're going to have a barbecue on the weekend. Everything must be properly documented. That's why I have written and transparent financial policies and practices. Any inadequate oversight of activities, these are the common pitfalls of NPOs. Common pitfalls. I don't want to say practices because I might be uncharitable, so we'll just use pitfalls, right? Right. Your beneficial ownership. Basically, the factor obligation zeroing on this because somehow they believe that people with ill intent infiltrate themselves as beneficial owners or members of charitable organizations. So when you are accepting persons as part of your membership to become a beneficial owner in your club, either by membership or otherwise, you have to do extensive due diligence on that entity or person to ensure that you are not admitting to your club, to your organization, somebody that should not be admitted. Because if you do, it means that your compliance program is not being adhered to and you would find yourself in problems. Again, the amendment that was recently enacted speaks to the fines associated with that beneficial ownership non-compliance. When you cannot track or give information as to who the beneficial owners of your club are, you would find yourself on the other side of the law. So you're supposed to know who controls the organization, who has influence over it, who is authorized to act on behalf of the organization, who has the document authority and decision-making authority of the organization. And I use an organization loosely, but you know I mean everybody, right? Because we started our very first slide to say everybody. Why do we have AML and CFT obligation? I spoke to this already because this is recommendation 8 from the Financial Action Task Force. Because NPOs are vulnerable, because they handle cash, they transfer funds to third parties, and some of them operate internationally. Either they are associated with an international body or their objectives extend into the international arena, and they worked primarily with vulnerable communities. So that those measures are what make them vulnerable for abuse by people who have, ill intent in terms of passing money through an organization that they wish to conceal. So some of the red flags. Yes, when a donor comes to you, we all need money. We all begging for money. It's not from the state, from private enterprise. But these are some red flags that you should look out for. Any anonymous donation, unusual cash contributions, funds coming from high-risk jurisdiction, donors who seek anonymity without explanation. So they don't want to tell you who they are. They just want to send you cash and not explain who is giving this money, who is behind giving the money. They send it through a third party. Or you are encouraged from your members or from your beneficial owners or from your controllers to engage in activities outside of your objectives. You're a cycling club and they tell you, well, tomorrow let's do this particular activity, but it's not within your stated purpose. Or they come up with some new activity or objective that you should engage in. And you don't conduct the necessary due diligence to ensure that that purpose is not going to land you in any problems. When I was putting together the presentation last night, something came to my mind. And I said, I wonder if folks in Trinidad know that per capita, Trinidad had the largest quadrille of persons who migrated to Syria to fight for ISIS. Yeah. Per capita, we had the largest number of citizens, women, men, and of course, they took their young children with them, to go to Syria. So imagine they come to the community and they form themselves in an association and into a body to raise funds. Because you say, well, yeah, they're going off on a holiday, you might think, or they're going to fight for a good cause, which it was not, because ISIS is identified as a terrorist organization. And you assist with that, or you use your organization to contribute to that. I think somebody earlier said they're not involved in an NPO, but they contribute towards NPO activities. I think it's your member. They give funds to different NPO activities. If you are not tracing where those funds are going to end up, it will be that your funds, which might be legitimate funds, are being funneled towards activities that are in contravention of the act, which comes back to activities inconsistent with your stated objectives. So it might seem innocent, but it has serious repercussions. Yeah. So in terms of AML and CFT risk, this really is what the true focus of the act is, I have to tell you. So all of the amendments that are being made is ready to tighten our AML and CFT obligations. The state, the authorities, which would be the Financial Intelligence Unit, the Counter-Trafficking Unit, and the Office of the Registrar General, they all have their microscope on the NPOs to just ensure that the AML and CFT risk are alleviated. So they want the NPOs to identify any red flags, but you don't just identify it and do nothing. You have to report it. Yes, you have to conduct due diligence on those who are seeking membership into your organization and those who are contributing towards your organization. You have to maintain a compliance file and respond to any request from the Financial Intelligence Unit, which brings me to the point as to what is the purpose of the Financial Intelligence Unit. So basically, the Act has put the Financial Intelligence Unit as the regulator for NPO. So although your registration is with the Registrar General's Department, which is the Ministry of Legal Affairs, you are regulated, monitored, and supervised by the Financial Intelligence Unit. Why? Because when the NPO Act was passed, the Proceeds of Crime Act, which is the big one that deals with money laundering, counter-trafficking, and proliferations of weapons of mass destructions, that act was amended to include NPOs as a listed business under the first schedule. So once they added NPOs there, which is what a lot of people miss. So like my practice professionally as an attorney at law is listed under the first schedule of the Proceeds of Crime Act as a listed business. Why? Because I do conveyancing, and they think money launderers like to go and conceal their money through buying and selling a real property. I don't know about that, but that's what they assume, right? So I have very stringent compliance requirement for my practice. This has now extended to NPOs. NPOs must adhere to these very stringent compliance objectives, and most NPOs don't even know what they are. They don't even know that they are now captured under the Proceeds of Crime Act, and they are required to comply with the provisions of the Proceeds of Crime Act. So let me give you an idea of some of your requirements. You have to have a compliance program. You must put a compliance program in place. This compliance program will detail your onboarding mechanisms, who are controllers, who are your members, how you admit members, how you get funds, how you spend your fund. Everything goes into this compliance program, and it has to be approved by the Financial Intelligence Unit. You must have a person who is a compliance officer. This compliance officer responsibility is to ensure that you comply with the provisions of a compliance program. That's what the compliance officer. So the compliance officer will tell you if you're admitting to membership somebody who ought not to be admitted to membership, if you're receiving funds from somewhere that you should not be receiving funds from. You must have a designated compliance officer, who's somebody in the managerial realm of the organization, right? You must ensure that this person receives training every single year on AML and CFT requirements, every year, annually. You have to pay for that person to go and be trained. That's what I do in my firm. Not just that person, but every single member of my staff in my firm, I have to train every year in AML and CFT obligation, so that if somebody is trying to come through the back door, everybody in the organizations know how to identify breaches of AML and CFT provisions. And that's, as I said, that training has to be ongoing annually. You have to establish internal reporting structures and in place for your compliance program. Ensure that your compliance program is reviewed internally and externally by auditors. So internally, my compliance program is reviewed by my compliance officer and my internal accountant. Plus, I have to get an external auditor to come in annually and check and make sure that my compliance is intact. Because the FIU could at any point in time just go through the list of all of listed business, which, as I said, includes NPOs. They just go through randomly and they choose 1, 2, or 3 and say, okay, I'm coming to do an audit of you. No questions asked. The Act allows them to do that. I have been audited by the Financial Intelligence Unit. Just randomly, they just pull out 1 or 2 entities off the list and they said, we are coming, bring all of your files to us, we are auditing you. That's the reality of how the legislation is structured. So your KYC and your source of funds measures must be intact and show that you have a reporting structure for suspicious transactions, suspicious activities. You can't just say, well, you know, I'm a cycling club, I'm a golf club. What suspicious things can be going on? None. It don't matter. You don't even know sometimes when a suspicious activity or transaction is happening, because you don't have the procedures and policies in place to identify what is a suspicious transaction or suspicious activity. So you have to establish that you have that in place and you have the proper requirements. So this is what I spoke to earlier. Some of the consequences of non-compliance. Investigations by the Financial Intelligence Unit. And as I said, it could happen randomly at any time. They could just send you a note telling you, we are coming to investigate. It don't even matter if you're making $50. If on that questionnaire you say that your annual income is $50, it doesn't matter. They will come and they can audit you. Deregistration. You could lose your registration status as an NPO. And imagine if you have donor financing, donor funding, coming in, and then you lose your registration as an NPO, as an established club. It's reputational risk, so which is what I have as the third one, reputational damage. Then we come to the penalties. I draw your attention to some of them. I actually have 2 more on the slide here. Where again, $50,000 and the imprisonment when it's the controller, and $50,000 when it's the NPO. And Kamala spoke to this earlier, loss of donors' confidence. Right now, you know, the more astute private sector entities are asking certain questions of entities in the NPO sector when they come to them for funding. In particular, to prove that you have duly registered and you have all of your records in place and you have a bank account before they even consider giving you any money. So just to zero in on these 2 offenses that I have on the slide. If you've registered, so you tick that box, good, you have your certificate of registration, but you solicit funds or cause funds to be solicited, whether it's locally or internationally, while you are not registered or your registration process has not been completed, that's an offense. And remember, I start off saying registration is now mandatory. If they come up with upon you yet, it's just because they haven't found out. But if they do, you can be in trouble. So you want to avert that trouble. That is the NPO, the entity, right? So the entity will be fined $50,000 for trying to raise funds while not being registered as an NPO. That is an offense. The controller, which is who are the persons now in charge of that NPO, the controller of that NPO is also guilty of an offense. and equally liable to a fine of $50,000 and the imprisonment. You can't jail the entity, but you could jail the persons behind the entity. So it's really looking at $100,000 across the board, and then the persons in charge of the entity with the 7 years imprisonment for simply soliciting funds from the public while not being duly registered as an NPO. Right. I've sort of identified on the schedule what are the top compliance pitfalls, because at the end of the day, this is a compliance session, right? You don't register or you don't maintain your registration. I remember, say it doesn't stop at registration. You don't file your documents on time. So you have late or non-filing. So that's why that calendar is so important. Populate your calendar with important dates so that you have triggers, 1 month prior triggers to remind you, because of course, there's so much our brain could take. So we need to have the technology to help us, right? You don't keep records. Remember I said, if it's not documented, you can't prove it. How did that big red building get built? It's not documented. You can't prove it. There's no evidence. You
Sonji,
have
I
weak
just want,
financial. What's that,
yeah,
Carla?
yeah, just wanted to give you a time check because I know a lot of the participants here also want to see the registration
I
process.
have that coming on the next slide.
Right. So, and let me just also tell participants, Sanji, once you have time, we're going to extend the session because there are quite a number of questions in the chat. So we will deal with all of them once you've completed that part as well. So,
Yes, because I am in the gear, I have not even
yes,
looked at the chat. You know, attorneys get carried
that's
away
okay.
talking.
I will bring all the questions to your attention. Go
We
right
have
ahead.
that weakness that we talk too much. So poor record keeping, weak financial controls, or you don't understand CML. How many of you on this platform knew that you were required to comply with CML and AML, sorry, and CFT requirements? I'm sure the majority of you don't. So failure to understand, failure to comply. You don't have proper boards in place. Conflict of interest issues. You're operating outside of the stated objectives of your NPO. Remember, I told you how easy you could get that happen to you. You fail to update the Registrar General regularly of changes in the information relating to the NPO. Or your compliance is treated as, oh, that's a legal thing. It's not for me, it's for the lawyers. It's not. It's a governance issue. It's proper governance of your organization, your club, your association at the end of the day. So the meat of what we are here today to talk about. So the next 3 slides is very wordy. They are very wordy. I apologize, but don't worry. You are getting these slides. All I attempted to do is to try to stack all of the information inside the slide for you. So basically what I did is pull the information from the Form 1 and put it on a slide, and pull the information from the risk-based question and put it on a slide. So those are the 2 documents that you're required to complete, right? To register, you must complete a Form 1, and then you must complete the risk assessment questionnaire. If you are a company, then you have to complete the risk assessment questionnaire. So this is the information for registration: name, status, telephone number, address, principal address, mailing address, as the case may be. These are the important parts. What are your declared purposes? You're putting it down in black and white. So here what now? You veer off from that, it's an offense. What you say as your stated objectives must be what you're doing. You can't say that you're a cycling club and then you say, okay, I'm going to raise money for brain surgery for somebody in the village and start to deal with something outside of what your stated objectives are. Unless, of course, it's a one and done. As I say, you have a one and done is okay, right? Whether you are affiliated to any parent body. Many of the NPOs, I think somebody earlier said that they were in the Toastmasters and the Rotary Club, affiliated with parent NPOs. You know, there's some NPOs outside that are not too kosher. So you have to make sure that whoever you're affiliated to outside, they are compliant as well. And if you are affiliated, you have to put on the form who are those entities externally that you are affiliated to. You have to list the name and address of every single NPO, and you have to give the IDs. You have to say how they have become an NPO. Their treasurer, the chairman, the president, the vice president, the board of directors, the managers, the case may be the CEO, how they have been identified as an NPO. You have to list your members, all. You know why? Because every time your membership change, you have to tell them. Members come, members go, you have to tell them. Yeah. You have to say who the founders are. If you're a club that existed since 1930, I don't know how you're going to get that information. You know, you might have somebody in the family who might be able to help you, but don't make up any information. Try to be as accurate as possible. Who the founders are, who the beneficiaries are. Because listen, the members who really would be the ones benefiting from the objective and purpose of the NPO may not be the beneficial owner of the NPO. The Act recognizes that. The Act recognizes a difference between a member and the beneficial owner, the one who really owns things. And that's who they want to be identified as well. So if your member and your beneficial owners are different, you have to identify and list them. And as I said, identification, valid identification for everybody required. So this is the Form 1. Yeah, for those of you who don't have it, I'll share it with you as well. And I probably might be able to pull it up if my slide works. And then this is the risk-based assessment. So, you know, a lot of information cramped into there, and it's 2 slides of it. Same information in the first 4 or 5 bullets, name, address, status, and stuff like that. Where it becomes very meaty is when you start to get into the specifics. You have to indicate not just what activities you plan to engage in, but the percentage. So like if, for instance, if you say that I'm dealing with educational, I'm dealing with sporting, whatever, you have to say what percentage of your objectives will be directed towards. If it's 50% education, 50% for sporting, or, you know, 25-75 as the case may be, they want you to indicate using a percentage basis what activities you intend to engage in, so that for monitoring purposes, they're able to monitor you properly, right? If you are engaged in any activities listed separately under the first schedule of the Proceeds of Crime Act, you have to identify that. You know, some NPOs are connected to companies that do other things. You have to identify that as well. If you are associated with an affiliate outside, just as on your form, it comes back and it repeats itself on the risk assessment questionnaire. Remember the name of this questionnaire? AML, CFT, PF. PF stands for proliferation of weapons of mass destruction. Risk assessment. So what they're doing, they're assessing you on your vulnerability for any of those things, that people could use your entity for the purposes in contravention of the AML, CFT, and PF legislation. On page 2, page 2, which continues, your bank, your estimated annual income. Remember, income, as I said, very holistic in its definition. I gave you all of the items that qualify as your income, where you expect to get that income from. If you've been operating for 3 years or more, they want to see those inflows and outflows. That's why your bank statements will be monitored. And then you want to know if you have a threshold of money that you would receive, so that when you get money above that threshold, you have to be able to account for it. Yes. They want, again, percentages of any receipts that you've received from any donor, whether it's cash, check, credit card, you know, direct transfer, wire transfer, any kind of receipts that you've received or will receive. You know, it might be futuristic because it's a club, people will be paying subscription fees, membership dues, as the case may be, that you have to list on the form, and the percentage that you would receive by those different mechanisms. Donations, locally, regionally, internationally, you have to state them, who you're getting those donations from, and then you have to indicate if you expect or likely to receive any contributions which will be considered unusually large, which is identified as actually over $50,000. Very small, but that's what the act is, right? So unusually large transactions of over $50,000, contributions, you have to identify that. And then you have to indicate your top primary source of income. Where would you be getting funding from in the 3 main respects? So that when we see funding coming from something external to that, those 3 that you put on the form, remember this form is there in black and white in the public domain with the Registrar General. So if you get funding outside of that, you have to have the documentation, and you're able to explain how you get this funding outside of your main source of funding that you would have identified. And then the rest is like employment and staffing and stuff like that. So I don't know if this will work. TT BizLink is where you start off to register. What I went through first off was the Form 1. I have the link. I doubt it will work, which would take you to the Form 1. Oh, it does. There you go. So this is the Form 1. As I
Yeah,
said,
but
all I did in the slide.
it will open for you, Sonji, but this
Oh, it doesn't
details
open for
of
you
the,
guys.
yeah,
Oh,
it's only
gosh.
to change your screen.
Oh, gosh.
Yeah,
Sorry about that. So it did not
that's okay.
open, but you are going to get it.
Mhm.
As I said before, let me just see what is on my last slide, because that slide was just supposed to take you to the forms, but these things don't work. And then my last slide probably was my Q&A slide. So those were the Form 1, the
Mhm.
Form A, which is the risk-based questionnaire. As I said on my slide, I just took all of the information from the risk assessment and I put it on the slide. And then there's a frequently asked questions document that was produced by the Registrar General's Department. So those of you who don't have it, you're going to get it. I'm going to share that with you, which might answer some of the questions that I have not captured as yet. I hope I captured all. So in closing, some questions that you need to have in your mind. You're registered, your filing's up to date, your record's complete, you understand your AML and CFT obligation, most importantly, and make sure that you have implemented effective governance and controls. And I ended with my ending salvo that compliance should not be viewed as a burden. It is a governance tool that protects the organization. It strengthens stakeholders. Kamala spoke about this earlier. Stakeholders, donors' confidence, and ensure that our scarce charitable resources are in fact applied for the purposes intended. Well-governed institutions or well-governed organizations are not merely compliant, they are resilient, trusted, and sustainable. And I think that's where I say thank you and invite your questions.
Great, wonderful. Thanks so much, Sonji. We do have quite a number of questions in the chat, so I'm just going to start raising them with you now. The first, and I'm going from the earlier questions. So Joanne Sankarali asked quite a few. We'll start with her first question, which is the controller mandatory for a director or optional for whom chooses to be included as a controller?
Once you have a nonprofit company, all directors are controllers. So let me summarize. You're in a nonprofit company. So once you're talking about director, it means that you have a board. And if you have a board, it means that you're a company, a nonprofit company, right? So every member of your board, they are classified as controllers. And the person who also exercises management control, which would be your CEO, or if you have a GM, as the case may be.
Okay.
You have to list them. So on the form, you list all of your controllers and then you identify the one that identifies management control. So usually what we do at the chamber, we say is we can put the president or the CEO, the one who would be the I use the main, that's my word, but that's not in the act, right? The main controller, which would be the one that the registrar General's department will be interacting with for compliance issues, because your board could change, but your CEO would remain stagnant in the
Right.
main.
Yes. Okay, great. And you had mentioned also organizations receiving not just cash, but goods in kind. And so Claire Orr had asked, do you have to quantify goods in kind? Like if you
Yes,
get
you have to put a
donated
value. They
water.
require percentage. So you
Yes.
have to be able to value it. And sometimes your donors are able to tell you, they say, I'm giving you $100,000, 50,000 in cash and 50,000 in kind, whether it's, as I said, internet services, mobile services, whatever. You're able to you have to state a value.
Okay, great. So that answers her question, as well as Joanne had also asked about that. And then there was a question from Sharon Rampersad. Does asset, like for instance, the donation of a printer, have to be quantified and brought into the financial statement and asset register?
And your asset register,
Yes.
yes. It is
Yeah.
an item owned by the NPO. So all items that belong to the NPO must be listed in your asset register. That's why you have to keep this running asset register. Yeah.
Yes. Great. There's a question
And
now
just,
from
Kamala, let me just qualify that a little bit. There is a reason for that. It seems draconian, but it's for you to explain unexplained wealth. You end up with an asset that isn't on your asset register. How do you say this is yours? So that's why your asset register is so important in terms of detailing the assets of the NPO. So it seems frivolous or a little draconian, but there is a purpose behind it.
Mhm. Okay, excellent. So Giselle Crooks Matthews asked, I saw on the newspaper recently that several companies were struck off the register for failure to file annual reports. What's the process if they have to register? Well, not with
So
an NPO, but as an
just in
NPO.
terms of an update on that, so the Registrar General's Department did put out a publication of NPOs that had not complied and had not registered as yet, and non-profit companies. So they would have a list of all of the non-profit companies there. That's easy. Remember, they don't know all the non-profit organizations in Trinidad. That they don't know. But they know all the companies incorporated as non-profit companies. So what they did is that they published a list of these companies who had not fulfilled their obligations under the NPO Act to make sure that they were duly registered by completing the risk assessment form. So they said they were going to strike off those companies, but they pulled back from that because the online system that allow the companies to be able to get their information into the Registrar General's Department wasn't working as it's supposed to. You know how technology is as well. So those that were listed in the newspaper as being struck off were not struck off, if you were worried. But you still have to make sure that you comply with the act. So basically what you could do, take that public notification as just a wake-up call. Listen, you were supposed to do something. That's why I said it's mandatory and the grace period has expired. So you get it done. You can, in fact, get it done. Now, if your company was in fact struck off, so that notice, those companies are not struck off, right? But if you were struck off, how many years ago, you could in fact apply to be reinstated. So there's a process under the Companies Act that companies can apply to be reinstated as a duly registered company and then fulfill its obligation under the NPO Act. We're speaking about companies here, right? Clubs and those things, they were not in that list because the Registrar General has no idea of clubs that are operating as clubs and supposed to be unless they're living in a community and they know what people do it. Yeah. Sorry, go ahead.
Okay, so that means that everyone at this point still needs to go through that process. If you're not registered yet, become registered. And then if you are registered, as you said, make sure that your information is up to date.
Yes.
There's a very interesting question from Roland Bertrand. He asked, what about a case where some directors are appealing to controllers to become compliant with the NPO provisions, but they are dragging their feet? What can these directors do?
Get off the board. They did not see the part of soliciting funds when you're not registered.
Yeah, because you once you're on the board, you are a controller and can be held
Yes. No,
liable.
no. I mean, the
Now,
encouragement could be a little bit more forceful in the sense that you could take the initiative to get it done. But if you are part of an NPO, an NGO, and they are refusing, not that they're unaware and just taking some time to do it, they are refusing to become compliant, I would be a little bit wary to remain a part of that entity because I don't want my name to be called up in anything when an investigation ensues.
right now, just to say for some persons who are trying to be compliant, it is not an easy process. Very often you go to Registrar General's Department and you get certain kinds of advice and guidance, and you go back to make the changes to comply, go back to the registry counter, and you meet someone else who has a different guidance to give. In which case, you should just be asking constantly for that update. How often have you gone? What are the changes? And demonstrate that the organization is attempting to be compliant. But that's just a challenge that all organizations do have to contend with. But Sonji is quite right. Just make sure that you are telling persons how important it is. Let me just also ask, the link for your feedback today is already put in the chat. And so we really would appreciate if you give us your feedback at the end of the session, please, right? Now, to continue with the questions, Joanne Sankarali asked, are NPOs required to follow the IFRS, and how are funds that come in through donation boxes treated? For example, through churches, spiritual organizations where funds come in anonymously. And what is the quantum for use of the KYC form? Is it over a certain dollar value? So those are three questions for you, Sonji. The
Okay,
first,
so let me
of
start
course,
with the
is
last first. The KYC is for everybody.
Mhm.
So just to give you an example, on the board that I sit, and I was really very in much the one encouraging my board in terms of what is required for our KYC process. Every person seeking membership to the organization, the board has to review it, and the board has to make sure that that particular member is in fact compliant. If you're a company, your registration, certificate of registration, incorporation, your annual returns, blah, 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 before the board of directors sign off your membership to that organization, right? So your KYC has no dollar value. Your KYC is for those who you admit into membership to your club, your organization, your nonprofit company. Yeah. Source of funds where you have a dollar value. So the source of funds require you to have your persons who are contributing financially to the organization to explain the source of their funds. So the threshold for that is $10,000. So in the main, the club fee, subscription fees, a couple $100. So you can account for that. And somebody asked about the donation contributions in church. Again, I don't know. Some people still put 25 cents in the box. I don't understand why in this day and age, and we put a little blue note, right? So that you don't have to fill out a source of funds form. You don't have to pass source of funds forms around in the church because those contributions are under 10,000. If somebody drops an envelope for $100,000, you would be in trouble. You need to track that down, find out who put it there, and give it back, or get the explanation as to who gave it anonymously. Yeah. So the source of funds is where you have the financial threshold. Under $10,000, okay, above, they have to identify the source of that funds for you.
okay. It's important to know that there's a $10,000 because
There's a threshold.
a lot of spiritual organizations, receive financial support from their members in that way. So at least if you're given, it doesn't have to be that every person who puts a $5 or $10
Have to
has
say
to
the
get
source,
right.
yeah.
Right.
And
Okay, so
even the clubs mainly receive, very small quantums of money. Where it comes up, and let me just put this in the mix. This aspect of what we're talking about, KYC and source of funds, isn't under the NPO Act. This is under the Proceeds of Crime Act, under the Financial Intelligence Unit Act. That's where those obligations come in. So that's where that financial thresholds come in. So equally, while I'm saying under $10,000, you don't need to come and say where you're getting money from, bring your job letter, payslip, blah, 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 bank statement, blah, 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 pass out the form in church. No. But if you have somebody every time giving you $9,999 in a series, that is a suspicious activity. Just under the limit in a continuous series or sporadically, that is under the limit, but it is suspicious. You need to now get that person to fill out your source of funds so that you cover yourself. Remember, I said if it's not documented, it is difficult to prove that you are compliant. Kamala, remind me of the first question.
the IFRS, is
Oh,
it
yes.
that? Mhm.
So this may not apply to some of you, but it may apply to some. 500,000 annual revenue. Remember, I said revenue is not just the income, right? Revenue is everything. I went through the detail from the act for you. I actually quoted the section of the act that listed all of the items that are considered income. So once that dollar value, value amongst the 500,000 or more, you are required to be IFRS compliant.
Okay, great. We do still have some other questions, but I
Let's
see
see. I
President
think this Mr.
Figaro.
Fugaro had his
Yeah.
hand up a little while.
Yeah, so let's just have you unmute and make it very brief if you can, please, Mr. Figaro.
Hi, good day, everyone. I'm Kelson Figaro from the Trinidad Tobago Rugby Union. I'm honorary secretary. The meeting just gone a lot beyond the way which we prescribed to be, so I need to be somewhere. So just wanted to address a question I was asked in the group. right? Firstly, so I'm part of the rugby union, and we have members under us, which is teams under us, right? And they are registered with us. Could you get a bit disparate as if they have to individually apply separately, or they
Yes.
register under us and we register them, as well as we have affiliate bodies that work with us. They all apply separately. That's my question.
Your responsibility to affiliate bodies, unless it is a body that you have control over, will be a little bit limited. If it is that you exercise control over those affiliate bodies, then there is a responsibility to ensure that they are registered. But to come back to your principal question, you have an overarching association. So in your instance, it's a rugby association. And under your association, there are many rugby clubs that are members of that. Each one of those clubs are, in fact, NPOs. You're an MPO, they're an MPO. You register, they register. So your registration doesn't mean that they are registered. Remember the definition. If we go back to the basics, my second slide, anybody coming together. They are separately coming together as a club for a purpose. They are part of a parent association, but they're also an individual association that came together for a specific sporting purpose. So yes, they are required. So they can't tag on to your certificate of registration, so to speak. Your certificate of registration is for your parent association, that is the association of associations, and then the associations that are part of your associations are required to be registered NPOs.
Okay, thank you very
Affiliates,
much.
as I said, if you exercise some kind of control over those affiliates bodies, then you should ensure that they are registered. But if you're affiliated to them, then you should carve off that responsibility to them, but ensure that they are aware of the requirements of the Act.
Okay,
thank
Kevin, thank you. Thank you for your
I
question.
think he had one more question. Wait, just now, I think
just one more
he said two
question.
questions.
Yes.
Yes, sorry.
Yes. No, sorry. I just need to leave. And you said that these slides will be shared. It will be shared in the link, or will it be emailed back to us?
We will email all the participants a link to the YouTube channel where we will post this recording for you as well. So whatever you miss, you will get that. We would also send you the copy of the slides from Sonji. We'll send that to you via email. So you'd look out for it. It would be an email coming to you from the Institute.
And not just the slides, I promise you the registration form, the risk-based questionnaire form, and the FAQs form. So 4 things you get in from Kamla, from me. Yeah.
Thanks a lot.
Yes. Okay. All right. Kevin, I need to ask you to be very brief because I know you like to start with an introduction when you are commenting, but let's just get your question briefly, please, because we do
so let me just ask these two quick questions to Sonji to hear her expertise on this based on how I would have answered this previously to a number of people. So question 1, if the NPO Act promotes transparency and accountability, who ensures that the regulators themselves are transparent and accountable? And the second question is, if governance failures continue despite increasing regulation, is the problem the law or the lack of enforcement and leadership?
Very heavy loaded questions, Kevin. But in terms of the first one, so the Financial Intelligence Unit is the regulator, as I said to you, right? And the Financial Intelligence Unit Act has very stringent statutory provisions relating to the persons who are involved in the regulations of all listed business. So it's not just NPO. Remember, my personal practice as a lawyer, I am required to be compliant. So any breaches by the personnel connected to the FIU has resultant consequences. So I might be, a little airy-fairy in my thought processes, but I feel confident that the statutory framework or the legislative framework that's in place for the governance of the Financial Institutions Act, Intelligence Unit Act, has the sufficient guardrails to ensure confidentiality of investigations, information, and transparency. I don't get that the FIU would embark upon an investigation without some transparent accountability. I think where we have identified where the FIU has fallen short is that we have not really seen many prosecutions resulting from breaches of the Act. They have identified, so annually they put out a dollar value of suspicious transaction and suspicious activities, but we don't see the resultant prosecutions from that, from the TTPS and the fraud squad. So that's a separate debate. The other one with the in terms of governmental aspect of it and the administration, I mean, I don't think I can speak to that. My task really was to just provide the knowledge for participants to understand what your registration is for you participating in this sector, not to discourage people from the sector, because the NPO sector is, as Kamala said in her opening speech, a key part of society. But coming out of that, we now have statutory requirements and obligations that we must conform to. And that is what I would want to speak to today. Yeah.
Yes, and I want to say we could just encourage people to engage in good governance practices, because we all live within our societies and we want to have a well-run society. And the most we can do is really appeal to people to ensure that you're putting the best practices in place. And at CCGI, we offer training for persons who want to learn how to improve your governance practices, okay? So I am seeing Adrian's hand up, but I want to just take a few more questions in the chat, and then we'll come to you, Adrian, because some of them can be easily dealt with, I hope. For instance, Susan is asking, Susan Morgan, the Form 6, Sonji, she's actually complaining that registry is not stamping it like the annual return, so the NPO has no real evidence other than the receipt that Form 6 has been filed. And then subsequent to filing, the registry is raising its own queries. So you can't speak on behalf of...
I can't, but I can say this because, of course, my practice as a lawyer include corporate services, so I know what Susan speak about. I know the headache, especially when it comes to the filing on the cross systems. So recently, and this is probably in the last 4 to 6 weeks, right, the Registrar General's Department through Companies Registry had introduced a new process where you deliver the document. They don't stamp it registered as they did long ago. They stamp it as uncertified, where they then check that data to make sure that the data is consistent with the data they have there, and they will then raise questions if the data is inconsistent, before they accept it as registration, accepted for registration, which we, the Law Association, and a committee of which I sit as the Law Association, had raised with the Attorney General and the Minister of Legal Affairs that is not within the provisions of the Companies Act. So the Companies Registrar cannot say, I am holding back your registration. It has to be at the presentation, but that is an issue to be resolved at that point. But the bigger picture, Suzanne, is this, which is the point I made earlier, the accuracy of your information, which some of us, and of course I would take responsibility for that if I fall short. If the information I am presented to the Registrar General is not information she has, then the responsibility lies with me. If I've had change in directors, change in controllers, change in membership, and I didn't give her that information, and she takes a document for registration, she said, wait now, before I accept it, I want to verify that what you're saying here is what on my records, which is basically what she has introduced. We say that she doesn't have the statutory power to do that, but that's been dealt with at a different level, okay? Let's come to our obligation. Let's come to the part where I said, make sure your record keeping is accurate and make sure the information that the Registrar General's office has is the information that you have. She don't have one thing and you have one thing, and then when you come to file, she say, but you have people who there, who this, who that, who not there. And that is what she was trying to cure by introducing this measure. Whether she has the statutory power to do it or not is what we were questioning separately, the Law Association, that is. But you could see her point, in the sense that there are many organizations that their information are not tallying up with her records. And it is because, truthfully, their record keeping is a little bit wanton.
So a related question from Joanne is, how does an NPO obtain copies if they were not aware to keep copies prior to their filing?
You can get it online. The Registrar General's office records are public. If you have a subscription, as I do, you go online and you download it and you get it. Or if you don't have a subscription, you are entitled, because the Act makes it public records, which ties into the question that Kevin was speaking about, transparency and accountability. It's public record. You could go in and pay for a duplicate. You could say, well, I have misplaced this particular document, and they charge you, I think it's $40 or $100 or something, to get a duplicate of that document that was registered with them, so that it is certified as an authentic copy coming from the Registrar General's office. We do it all the time for our corporate clients.
Okay, I'll take this one question and then we'll come to Adrian. It's from Dave Ramrup. He asks, what happens if a registered NPO is no longer in operation?
You can apply to be delisted just as you can with a company. So under the Companies Act, you could go through the process of saying that, I winded up this company and I want to get the company delisted of the register of companies. Same thing with an NPO. If it's not a company, right? So you have a process for a company as well. So if it's not a company and it's just an NPO, you could just apply to have the NPO delisted. It's a very simple process.
Okay, excellent. So, Adrian, we would allow you to unmute and keep your question very brief, please, because we are over time at this moment, right? So, go ahead, Adrian Edwards.
Hi, well, thank you for allowing me to ask the question. And Sonji, I love your presentation, very thorough. I really have some important question here, right? But I know you mentioned about the founder, right? And there has been instances where an NPO has been registered in 1930, like you mentioned, but the act came into effect in 2019 and so on. So in a case like that, right, I was told by the company's registry that the founder in that case would be considered the person who would have registered under the act. I mean, can you confirm if that is something you're familiar with? And the other thing is that an NPO, an unincorporated NPO, it receives donations, it receives grants, it receives funding from several organizations. Does that organization, NPO unincorporated, have to file a tax return?
No, tax return relates to companies. So if that unincorporates, it has to be incorporated as a company. Yeah. So you don't have the tax return to file for the organization because it's not a corporate entity. To answer your first question on the founder, so I would have had that when I was doing the process for the chamber, but of course our records are well documented. So we know who our founder was, right? Leo Agostini, 148 years ago. So that information was easily to be provided. But as I said, you may not know for those who are around in the 30s or 40s. So if you don't know, the Registrar General has been a little bit lenient with that information. Of course, if you were in existence many, many years ago, it can't be 10 years and you say you don't know. They're able to allow you to proceed with the registration on the basis that you state who now are the persons who would be carrying the organization or the club forward, to list those persons as the founders. So in response to your question, it would be yes.
Okay, and then just this last one too, right? Now, with regards to the members, I heard you touch on this earlier, but I'm part of a national sporting organization. And, we have members, we have affiliates and so on. Some of them are registered, right? Do we have to list that in our annual return or Form 1 in terms of all the members that we have that are affiliated with us, whether they are clubs or individuals?
If the affiliation is via a membership, yeah. So if they are a member of the organization.
Dues also, Sonji, to be a member of the National Association.
But if they're just an affiliate, then no. Who you're listing, what they're trying to track is where you're getting your income from. Those who pay in subscription, those who pay in dues, those who pay, So if you have an affiliate that, an organization that you are affiliated with, that you might have that classified as a member, but in the truest sense is not. What they're looking for is information as to the contributors of the club, the contributors of the organization, to the finances of the organization.
So I have a related question to that, Sonji. If your membership changes regularly, like you have new members joining every month, then is it that every time there's a new member, there's an expectation to update your records, or is it annually when you do your filing, that's when you list your membership?
So I had that very specific question put to the legal officer of the company's registry, of course, because that's the nature of the chamber as well. We have fluctuation in the membership all the time. So what we've decided in terms of coming to a midpoint, because it is administratively tedious, every time you have an
both
admission or
sides.
somebody attrition that you have to file a return. Is that you can do it on a monthly basis, like on the anniversary date, or when you are filing your notification of changes. So it is not every day or every other day. You could have a fixed period of time that you notify them. This is a revised list of members.
Okay.
So that was the midpoint that I was able to reach with the application of the law. And all of this is new, but it's trying to get a commonality that it become workable for those who are working the system.
Yes. Okay, I want to take one more question in the chat, and then we'll come to Tasha, who has her hand up. This is from Christiane Elcock. She asked, is it true that NPOs regulated under the FIU are only those that fit under FATF, the Financial Action Task Force definition of an NPO?
No, all NPOs are regulated by the FIU, which is the point I made. All NPOs are now classified under first schedule of the Proceeds of Crime Act. And all the entities listed under the first schedule of the Proceeds of Crime Act are under the regulation of the Financial Intelligence Unit. That's the logic of the analysis in terms of regulations and your regulatory authority. And the act is very clear. I think I identify the section of the NPO Act that says the Financial Intelligence Unit is the regulator of all NPOs.
Mm-hmm. Okay, great. Thanks. And let's go to Tasha. Tasha, please keep your question very brief if you can help it.
I think she probably forgot to turn on the mic.
Yeah.
Thanks again for a wonderful program. My question has to do with the subvention that is received from government institutions. Seeing that the act is geared to somewhat stabilize things and put us in a position where we become more compliant, how does that affect our subvention? And is it important that those government institutions somewhat liaise with that aspect of it so they too can ensure that those persons that they give the funds to, the NGOs that they give the funds to, are in compliance with the requirements under the ministry?
Well, Tasha, they're supposed to. And as I said earlier, I know many operators in the private sector realm are now very cognizant of the fact that you have to be registered. So before any donor funding is given, they ask you to confirm your status with the act. On the government side, in terms of the government subvention, the government are the one who have this act in place. So they should be the one to ensure that whoever is receiving public funds for which they are accountable are in fact compliant with the act. If they are not, I can't speak to that. They should be the ones ensuring that once they give subventions and grants to any NGOs, those entities are in fact registered, But what I would encourage you to do, you make sure that your business is in order. Don't fret about the other person so much. They will deal with that in a later stage. You make sure that you are registered. And then if it has to be raised as a concern holistically with the line ministry, like, why are we giving NGOs that are not compliant with the act subvention and state funding? Should we not ensure that? So that's a conversation you can have with them separately. But in terms of your personal obligation, the NGO that you're attached to, just make sure that you are good.
Thanks so much.
You're welcome.
Excellent. So we have a question from Sharon Rampersad as well. She says, if our registered NPO receive funds from a governing foreign body, do we also need to ask the governing body to fill out a source of funds declaration form?
If it's more than 10,000, remember that's the threshold I said, right? So if it's 10,000 US, yeah. The threshold on the act is 10,000 TT. So whatever that translates into US, equivalently, anything under that, you don't need to get the source of funds. But over that, for sure, you have to get source of funds completed. And how your source of funds is structured will be how your compliance program is structured. Because in your compliance program, you would have what information you solicited on your KYC form and what information you solicited on your source of funds. So it's not no drill long thing if it's an entity overseas. It's really just to satisfy where the funds come from. If it's a State Department, as the case may be. I think Giselle had her hands up, Kamla.
Yeah, so I'm going to Giselle. You can unmute now and ask your question very briefly. Hi, Sonji. This was an excellent seminar. Let me first say that exactly what I was looking for, because as the controller now of my club, I know we have some work to do. So from the filing of the annual return part to the registration of the MPO, how much or I know the law was enforced in 2019, but are we still allowed to do that? How much leeway do we have without being penalized? Because I'm seeing this 50,000 and 7 years. So, I'm getting heart palpitations. So how
Well,
much leeway do
the
we have to make sure
offense,
that we be compliant?
the offense really is on conviction. So they'll have to have an investigation and convict you on indictment where that 50,000 fine and imprisonment. But that's separate and apart from the administrative penalties. So you have a filing fee that you have to pay when you register and to file your annual returns. And the Act now provides if you file late, you have to pay a penalty. So what they have done, I must commend them on this. The penalty was $300 a month. They have now reduced it to $100 a month for late filing. So you have a date by which it has to be done. That's why it comes back to keeping that calendar running with important dates, right? So you have a date by which it's done, it has to be done. You have a month grace period to get it done. If you don't, then you start paying this penalty, which, as I said, was previously $300. It's now down to $100 per month or every month that you don't get it done by. So that is the part that you ought to be concerned with. The 50,000 and the imprisonment is if they come and investigate and convict you in court of the offense.
So that's $100 per month from 2019 to now then?
No. The from the extended period. Remember I said that grace period was extended several times. So I'll get the date and send it to Kamala. So when she's sharing the slide, she could give you the date.
Okay, great. Thanks a lot. Okay, great. There's a question from Susan Morgan that government is asking for board minutes. She wants to know, Sonji, if that is appropriate. I'm not sure.
I've not had that experience in my corporate services work. I've not had where the company's registry is asking for board minutes. However, as I said, because we are subject to being audited by the Financial Intelligence Unit.
No, she's clarifying. It was, they're asking for the minutes in order to, I suppose, give subventions. Well, for me, if you're getting public funds, then yes, you fill out whatever requirement they want. Important with respect to the decisions of the organizations and therefore how you're using it. These are very important things that must be traced.
Most important, I think that's what they want to tie it back to. Whoever the controllers, whether it's the board, the committee, the executive committee of the organization, because some clubs don't have a board, how that decision was minuted, the purpose of which the funds are to be applied for, that is what they want to see. They want to have physical evidence of that. So remember I had a slide talking about proper record keeping. So they are not wrong to ask you to produce that information. You're supposed to have that easily in your records to be able to produce to them, to be able to get access to public funds.
That's right. Joanne Sankarali said too that they're also asking for audited financials. I'm in total agreement with that. If you are spending public funds, government is giving you money, it should be that you have a process that you would demonstrate how that money is being spent, and that ought to be an audited process that brings confidence to the system that the money is being used the way it was meant to.
Yeah.
Okay, so I think that takes out almost all the questions that we had on the chat. So Sonji, I want to thank you so much for today's presentation and for spending this extra time with us, even as I'm talking to you, just looking through very quickly to see that we did not, in fact, miss out any pertinent question from the chat. I myself learned a whole lot listening to you today, Sonji, because as a nonprofit organization, we too have to ensure that we are very much in compliance, not only because we want to be compliant with the law, but because we also want to ensure that we are building and maintaining a good reputation, that we are maintaining trust with our members as well, and that we're just a good citizen, that is doing the best that we can to help make our society a better place. So Sonji, thank you so very, very much for your time and for all of the information that you plan to share with us that we will send to all of our participants. I know these are important things that can be confusing for some people, but Sonji, you have done such a great job in making it understandable and, alerting us to what we need to do.
It was my pleasure. I hope I didn't use too much legalese. I started off saying it would be practical and not legal, and I got into a little legal bit there. We can't help it as lawyers. But it was my pleasure. I'm happy to come back for the third time. Third time is a
Yes.
charm.
And you'd be sure we will invite you again, Sonji. That's based on the kinds of questions we get from participants. And if we see there's a need to take persons through this process again, definitely we'll be asking you. Sonji, also do include your information, your email address and all that in your slide deck. So when we share it with participants, they can email you if they want any further clarity. But you know for sure we will be inviting you back again to host a session with us and take persons through the registration process.
Most welcome. Always happy to be at your disposal, Kamla.
Thank you so much, Sonji. And
Bye, everybody. Sorry to keep you all 40 minutes after the hour, but I hope it was good. Bye, everybody.
Yes, thank you. Thank you all for joining. And you can look out for the email with all the information for you. And we would also alert you when this recording is posted on our YouTube channel, so you can go back and verify information or even share with your members so that they can be just as aware of what they need to do. So thank you all so much. Have a wonderful evening, and we will see you again for another CCGI session. Bye-bye.